Thank you to those of you that are here timely. I apologize for the irresponsible one that can't be here on time. At this point in time, I'm going to go through our instructions. You will be allowed to keep those instructions with you, so you don't need to make any notes lest we find some type of graphical error. What I would ask is that you follow along with me as I go through them so that I can be certain that everyone has been through them in their entirety on at least one occasion. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. Henry J. Segura, the defendant in this case, has been accused of crimes of 4 counts of first-degree murder. Murder in the first degree includes the lesser crimes of murder in the second degree, murder in the third degree, and manslaughter, all of which are unlawful. A killing that is excusable or was committed by the use of justifiable deadly force is lawful. If you find Brandy Peters, Tamaya Peters, Tanaya Peters, and Javante Segura were killed by Henry J. Segura, you will then consider the circumstances surrounding the killings in deciding if the killings were murder in the first degree or murder in the second degree or manslaughter, or whether the killings were excusable or resulted from justifiable use of deadly force. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. The killing of a human being is excusable and therefore lawful under any one of the following 3 circumstances. 1, when the killing is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent, or when the killing occurs by accident and misfortune in the heat of passion upon any sudden insufficient provocation, or when the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. Dangerous weapon is any weapon that, taking into account the manner in which it is used, is likely to produce death or great bodily harm. I now instruct you on the circumstances that must be proved before Henry J. Segura may be found guilty of first-degree murder or any lesser included crime. There are 2 ways in which a person may be convicted of first-degree murder. One is known as premeditated murder, and the other is known as felony murder. The state has alleged both theories as to counts 2, 3, and 4. To prove the crime of first-degree premeditated murder, the state must prove the following 3 elements beyond a reasonable doubt. 1, victim is dead. 2, the death was caused by the criminal act of Henry J. Segura. 3, there was a premeditated killing of victim. I'm not going to repeat that 4 times, so I think you all are smart enough to follow the same elements as to premeditated murder apply to count 1, which involved Brandy Peters, count 2, which involves Tamaya Peters, count 3, which involves Tanaya Peters, and count 4, Javante Segura. These instructions apply to all 4 counts. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The questioning of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. If a person has a premeditated design to kill one person and in attempting to kill that person actually kills another person, the killing is premeditated. To prove the crime of first-degree felony murder, which I said is the other theory that the state has asserted as to counts 2, 3, and 4, the state must prove the following 3 elements beyond a reasonable doubt. 1, victim is dead. 2, while engaged in the commission of the murder of another human being, Henry Segura caused the death of victim. 3, defendant was the person who actually killed the victim. As I've indicated, this theory only applies to counts 2, 3, and 4. In order to convict the defendant of first-degree felony murder, it is not necessary for the state to prove that the defendant had a premeditated design or intent to kill. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which he is accused, there may be evidence that he committed other acts that would constitute a lesser included crime or crimes. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crimes indicated in the definition of first-degree murder are second-degree murder and manslaughter. To prove the crime of second-degree murder, the state must prove the following 3 elements beyond a reasonable doubt. Again, this will apply to each of the 4 counts with the victims as I alleged to begin with. I'm not going to repeat it 4 times. Element 1, victim is dead. 2, the death was caused by the criminal act of Henry J. Segura. 3, there was an unlawful killing of victim by an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is eminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. To prove the crime of manslaughter, the state must prove the following 2 elements beyond a reasonable doubt. 1, victim is dead. 2, Henry J. Segura intentionally committed an act or acts that caused the death of the victim. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. Each of us has a duty to act reasonably towards others. If there is a violation of that duty, without any conscious intention to harm, that violence is negligence. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. As to counts 1 and 2, if you find that Henry Segura committed second-degree murder or manslaughter, you will ask to find beyond a reasonable doubt whether during the commission of the crime, Henry Segura used a firearm. You should designate this finding on the verdict form. Again, as to counts 1 and 2, if you find the defendant committed second-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime, Henry Segura discharged a firearm and in doing so caused death or great bodily harm to the victim, discharged a firearm, or actually possessed a firearm, you should also designate this finding on the verdict form. A firearm is legally defined as any weapon including a starter gun, which is designed to or may readily be converted to expel a projectile by the action of an explosive, the frame or receiver of any such weapon, any firearm muffler or firearm silencer, any destructive device, or any machine gun. The term firearm does not include an antique firearm unless the antique firearm is used in the commission of a crime. To actually possess a firearm means that the defendant carried a firearm on his person or had a firearm within immediate physical reach with ready access with the intent to use the firearm during the commission of the crime. The following comments relate only to the state's felony murder theory as to counts 2, 3, and 4. These comments have no relevance to your consideration of the state's premeditation theory as to counts 1 through 4. Counts 1 through 4 are linked in that the crime charged in count 1 is an essential element of the crimes charged in counts 2, 3, and 4. You should first consider the evidence applicable to count 1. If you find the crime in count 1, either first or second degree murder, has not been proved beyond a reasonable doubt, you must find the defendant not guilty on counts 2, 3, and 4 as to the felony murder theory. If, on the other hand, you find that the crime charged in count 1 has been proven beyond a reasonable doubt, you must then consider the evidence applicable to counts 2, 3, and 4. A guilty verdict on count 1 does not require a guilty verdict on counts 2, 3, or 4. You should find the defendant guilty on counts 2, 3, or 4 only if you find all the elements of that crime, including the essential elements contained in count 1, were proved beyond a reasonable doubt. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the indictment through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial, and to it alone, that you are to look for that proof. A reasonable doubt as to guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with the other testimony and other evidence in the case? Has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? Had any pressure or threat been used against the witness that affected the truth of the witness's testimony? Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Has the witness been convicted of a felony or misdemeanor involving dishonesty or false statement? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses, with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. You must consider the testimony of some witnesses with more caution than others. For example, a witness who hopes to gain more favorable treatment in his own case may have a reason to make a false statement in order to strike a good bargain with the state. This is particularly true when there is no other evidence tending to agree with what the witness says about the defendant. So while a witness of that kind may be entirely truthful when testifying, you should consider his testimony with more caution than the testimony of other witnesses. However, if the testimony of such a witness convinces you beyond a reasonable doubt of the defendant's guilt, or the other evidence in the case does so, then you should find the defendant guilty. The defendant in this case has become a witness. You should apply the same rules to consideration of his testimony that you apply to the testimony of the other witnesses. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. A statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including but not limited to whether when the defendant made the statement he had been threatened in order to get him to make it, and whether anyone had promised him anything in order to get him to make it. If you conclude the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. This case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of exhibits and evidence in these instructions. This case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Your duty is to determine if the defendant has been proven guilty or not in accord with the law. It's my job to determine a proper sentence if the defendant is found guilty. There are certainly some exceptions in this instance. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. The jury is not to discuss any questions that jurors wrote that were not asked by the court and must not hold that against either party. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. You may find the defendant guilty as charged in the indictment or guilty of such lesser included crimes as the evidence may justify or not guilty. If you return a verdict of guilty, it should be for the highest offense which has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous, that is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. The verdict must be in writing, and for your convenience, necessary verdict form has been prepared for you. I've given you the verdict form if y'all would turn to that. All right, if you look at the verdict form with me, we'll go through it. It says, we, the jury, find as follows. It's count one of the indictment concerning the murder of Brandy Peters. You would check one option, either A, guilty of first-degree murder, B, guilty of second-degree murder, C, guilty of lesser manslaughter, or D, not guilty. If you choose B, which is second-degree murder, then you need to answer the interrogatory. During the commission of the offense designated above, the defendant discharged the firearm causing great bodily harm or death, discharged the firearm, actually possessed the firearm, or did none of the above. Need to work down from the top, from the most serious to the least serious, find whichever one was proven, starting from the most serious. Then, if you choose B or C, which would be second-degree murder or manslaughter, you need to answer the interrogatory. During the course of the offense designated above, the defendant used the firearm, yes or no. That would be as to count one. Count two is similar to count one. Again, you have four options, A, B, C, or D. You would pick the one option you unanimously agree upon: first-degree murder, second-degree murder, manslaughter, not guilty. If you choose A, there is an interrogatory there. It says, we find that guilt is established by proof of premeditation and felony murder. Remember, I've explained to you the state has two theories as to counts 2, 3, and 4. Slightly different on the verdict form. Or we find that guilt was established by proof of premeditation only. We find that guilt was established by proof of felony murder only. Under B, again, you have the same interrogatories that you had under count one. You would start at the top with the most serious and work down. Discharge the firearm causing great bodily harm or death. Discharge the firearm, actually possessed the firearm, or did none of the above. If you choose B or C, you would answer, during the course of the offense designated above, the defendant used the firearm, yes or no. Looks like somehow in the process C got dropped out of that part of the verdict form, so that I'm going to need to correct that. So C is the option of manslaughter, and I will fix that. Give you a corrected verdict form. Now, we read these a million times, but sometimes we read them over things. As to count three, you have, again, four options. The defendant's guilty of first-degree murder. B, the defendant's guilty of second-degree murder. C, the defendant's guilty of manslaughter. D, the defendant is not guilty. If you choose A, you would have the interrogatory to tell us whether you find proof of premeditation. and felony murder, or just premeditation, or just felony murder, as you did on count 2. Count 4 is identical to count 3. You have the option A, first-degree murder, B, second-degree murder, C, manslaughter, D, not guilty. And again, you have the interrogatory, which tells us what your theory of conviction is if you convicted on count A. It would be dated and signed by the foreperson. The foreperson will bring the verdict form back to the courtroom with them after you have completed your deliberations. Occasionally I get a question from the jury whether all jurors have to sign the verdict form. That just the foreperson signs on behalf of the jury. Going back to the instructions, single defendant, multiple counts. A separate crime is charged in each count of the indictment, and although they have been tried together, each crime and the evidence applicable to it must be considered separately and a separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not affect your verdict as to the other crimes charged. I will go over the final comments with you after the attorneys have spoken to you in their closing arguments. The attorneys will now present their final arguments. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defendant has spoken. Excuse me.